the case that we are going to hear this week is cause number 23 DCCR 0944, and it's styled the State of Texas versus Michael Keith Brasher Jr., charged by indictment with the offense of aggravated assault against a public servant. And you guys, I don't have my indictment in front of me. Is it first or second?
It's first.
The punishment range for that offense is a minimum of 5 years in prison, up to 99 years or life in prison, and or a fine of up to $10,000. So that's obviously a very large range of punishment. We'll talk more about that in a few minutes also. We don't anticipate this trial to last longer than a few days this week. We don't anticipate it going into next week. I'm going to introduce to you all everyone that's here, and then I'm going to ask you all if any of you know any of us. Just because you know someone that's involved in the trial does not mean that you can't serve as a juror. We just need to know who you know, kind of how you know us, and then if you think that that relationship would cause you an issue in being able to be fair in this trial. So representing the state of Texas, we have Assistant District Attorney Tommy Coleman.
Good afternoon.
And Assistant District Attorney Kobe Hoffpower.
Good afternoon.
And then representing the defense, we have Mr. Ryan Matuska.
Good afternoon, yeah. And
the defendant, Mr. Michael Brasher. And then you'll see to my far left, again, Ms. Tanner, the court reporter. An important thing about her is that she's not just taking down what I say or what the attorneys say, but she's also taking down what you all say. And I know that public speaking isn't everyone's favorite thing to do, but we are going to ask you during this process, if you're speaking, to please speak loudly and clearly so we can all hear you. We'll also call you by your name and your juror number. That way the record is clear as possible as to who's talking at what time. If you have an answer to a question or something to talk about that you are uncomfortable talking about in front of 50 or so of your new best friends, all you have to do is say so. And what we'll do at the end of this process is we'll take a break and have all of you exit the courtroom. And if there's something you want to talk to us about privately, we'll bring you back in one at a time. We do that in every trial. Sometimes we do it because you want to come visit with us. Sometimes the lawyers want to visit with you a little bit more. What we don't want to happen is for you to have some kind of information that you're thinking, you know, they didn't ask this question. It might be important. I'm not sure. We want you to tell us that. And at the end of this process, I will actually give you an opportunity to let us know if there's something you want to talk about. We don't want you to end up on the jury and you're sitting up here and we're a couple of days into trial and then you say, I should have said something. I can't do this. Potentially what that could mean is that we would have to start all over and go through this process again, and obviously we don't want to have to do that. So this process, we try to make it informal, we try to make it comfortable for you to speak. I will and try and probably fail at some bad jokes. We and the attorneys may do the same. We don't want you to at any time to think that we don't think what we're doing here is important or serious. Everything we do here are felony criminal offenses, so it's all very serious. But the whole purpose of this afternoon is for you guys to kind of loosen up, visit with the attorneys so they can get to know you. We oftentimes call this jury selection, and it's really not a selection process. The attorneys don't get to say, I want this one, this one, this one, and this one, and that's not how we do it. So what happens is they get to know you, and for any number of reasons, they have 10 strikes. So they can strike people off for just about any reason. There's some exceptions to that. And then it's really the next 12, and then we'll have the alternate 13 that start from number 1 on. And so it's really kind of a deselection process. So it is important that you talk to them, let them get to know you so that they know what to do when it gets that time this afternoon with regard to their selection process or deselection process. I'm going to go through now and go again row by row and ask by a show of hands if any of you know any of us. And so starting on the first row, yes ma'am, we've got number 1, Miss Nobles. And who do you know, ma'am?
You.
And how do you know me?
Our sons went to high school and junior high together.
They did? And is there anything about that that would make you feel like you couldn't be fair in this case?
No, ma'am.
Thank you, ma'am. Anyone else on the front row on this side? Let's go across front row over here. Anybody know any of us? All right, second row then. Coming across second row coming this way. Yes, sir, you are, let's see, is it number 28, Mr. Tanner? Can you answer out loud?
Yes, that is correct.
Thank you, sir. That's just for the court reporter and us. And who do you know, Mr. Tanner?
The court reporter.
Miss Tanner. And how do you know Miss Tanner?
She's my niece, married by my nephew.
Is there anything about that relationship that would make you feel like you could not be fair in this case?
No, no ma'am.
Thank you, sir. Third row on this side. Yes, ma'am. Is it number 29, Miss Hinton?
Yes, ma'am.
And who do you know, ma'am?
Attorney Matuska from Juvenile Probation.
Okay, how are you?
I'm good.
Is there anything about that would make you feel like you could not be fair in this case?
No, ma'am.
Thank you, Miss Hinton. Anyone else third row coming across that way? Third row over on this side. Let's go to the back row, coming across all the way on the back row. All right, see, it's not that hard. Easy questions. So I'm going to go through with you guys just some general housekeeping matters, and then I'm going to go through some general legal principles that apply in every single case. Then I'm going to hand it over to the attorneys and stop talking. Again, the only thing that really is important this afternoon is that you tell the truth. That's the only oath you've taken. What we don't want you to do is try to answer a question in the way you think we want or the attorneys want you to. They really want to know what your thoughts are about the law and things like that. They are not, it can be frustrating this afternoon in this process because the lawyers are not allowed to discuss with you the particular facts of this case. And so they're going to be asking you questions in general or kind of, generalities and things like that. And so I don't want you to get frustrated with them and think your answer typically would be, I don't know. I don't have enough information. You didn't tell me about the case. They're not doing that on purpose to make you upset or frustrate you. They're not allowed to talk about the specific facts. That happens later when we have witnesses that are sworn to tell the truth. So they're not going to get into that right now. They're going to talk about type of cases, punishment, things like that. And so kind of just be open-minded when they're asking you those questions and understand that that's what they're limited to. Our trials here in criminal court take place in two phases potentially. The first phase of our trials is the guilt-innocence phase. And then if there is a finding of guilt, the jury or the judge assesses punishment. And it is the election or the choice of the defendant as to who punishes him if he's found guilty. In this case, the defendant has elected, if he is found guilty, that the jury would assess punishment. And so I will talk a little more about punishment, and the lawyers will talk a little more about that, because that will become your job if the defendant is found guilty at trial. You do not have to have any kind of special knowledge or have been on a jury before to be qualified to be on a jury here in felony court. You will get at the end of the trial what's something called the court's charge, which is actually a written document that I provide to you that contains everything you need to put together with the evidence in order to reach a verdict. It will have instructions, the law, definitions, everything you need, so you don't need to have any extra information. In fact, if you're on the jury, you'll be instructed not to try to get other information. We don't want you Googling things or trying to figure out the law or anything about the case. It's very important that what you base your decision on comes only from here in the courtroom. Let's see. Again, it's going to be important that you speak loudly and clearly. Again, we'll call you by your name and your juror number so that the court reporter can take everything down that everyone's saying. I'm going to now talk just briefly about some legal principles that apply in every single criminal case. The first of those is the presumption of innocence. Our law provides that all persons are presumed innocent and that no person may be convicted of an offense unless each and every element of that offense is proved beyond a reasonable doubt. The law does not require the defendant to prove himself innocent or to produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt. So, if you were asked to vote right now whether or not the defendant is guilty or not guilty, what would your vote be? Okay, see, it's easy. So the state has the burden of proving the defendant, proving the defendant guilty by proving each and every element of the offense beyond a reasonable doubt. And if the state fails to do that, then you must find the defendant not guilty. I have used the term beyond a reasonable doubt now several times. And many years ago, there was an actual definition that was given to jurors as to what that meant. The highest courts in the state of Texas, however, have abolished that rule and no longer allow us to define that for you. I think that means two things. I think first, you decide for yourself what beyond a reasonable doubt means. And then second, you decide if the state has proved each and every element of the offense beyond a reasonable doubt. I'm sure the attorneys will talk to you about that more, but ultimately that is your decision on what that means and if they have reached that burden. Our law provides that a defendant may testify on their own behalf, but that same law, as you all know, provides that if a defendant elects not to testify, you cannot use that against him. And you can't talk about it. You can't talk about with other jurors about what he might have said, why he didn't take the stand. You cannot infer guilt from that. That's everyone's right. We all have the Fifth Amendment right not to testify against ourselves. And there are many, many reasons why a defendant would elect not to testify. They typically get advice from their attorney after the state has put on their case. Not everyone, as you all know, are...
The courtroom opened as Judge Raquel West introduced a serious criminal trial involving a defendant charged with aggravated assault against a public servant, an offense carrying a possible sentence of 5 years to life in prison. The judge carefully explained the jury selection process, reminding potential jurors that fairness and honesty were the most important responsibilities. She emphasized that the defendant is presumed innocent unless the state proves every element of the charge beyond a reasonable doubt. Jurors were instructed to decide the case only from the evidence presented in court and not from outside information. The judge also explained that if the defendant chooses not to testify, the jury cannot hold that against him. The hearing served as an important reminder that every criminal trial begins with fairness, impartiality, and the rule of law. What do you think about these courtroom rules?